What every Social Security disability applicant with ischemic heart disease needs to know about the 5-step sequential evaluation. At step 1, the Social Security Administration wants to know if your ischemic heart disease has kept you out of work for at least a year or will keep you out of work for more than a year. The second question they have is whether or not you have a severe impairment, and most cases of ischemic heart disease are severe. At step 3, they'll want to know whether or not you meet a listing, and if you have ischemic heart disease, there is a specific listing for that criteria, and your records have to show that you meet every one of the elements of the listing. Now, it's not uncommon for those who have ischemic heart disease to have medical problems from other problems, such as diabetes. The Social Security Administration is required to consider the combined effects of all your medical conditions to determine whether or not your conditions meet or equal a listing. If you don't meet or equal a listing at step 3, all is not lost, because the Social Security Administration will determine your entitlement to benefits based on the medical and vocational criteria found at steps 4 and 5. This is the key, really, to getting your benefits, because unfortunately most applicants don't meet a listing. So the question becomes at step 3 is whether or not you can go back to the lightest physically demanding job you held in the 15 years before you became disabled, and whether there is other work you can do in the mythical national economy in view of your age, your education, your skills, and your residual functional capacity. And in my view, the key to getting your benefits at steps 4 and 5 is having a properly completed residual functional capacity form done by your doctor. Why is it so important? Because when you apply for benefits, the Social Security Administration is going to try to figure out what you can do. Can you do light work, sedentary work, medium work, heavy work? What kind of work can you do? And the residual functional capacity is crucial because ultimately the question is going to be whether you can go back to that lightest job you held in the 15 years before you became disabled, or any other job you can do in the national economy. So if your records don't speak to this, the Social Security Administration will have their doctors review your medical records. And more often than not, they'll opine that the applicant can do some level of work that will allow the Social Security Administration to deny your claim. The reality is, the lower your residual functional capacity, the more likely it is you can't go back to the lightest job you held in the 15 years before you became disabled. Now, the Social Security Administration won't tell you or your doctor about the existence and importance of a properly completed residual functional capacity form. These forms will explain, for example, how far you can walk, how long you can stand and sit at one time and for an 8-hour workday, how much and how often you can lift, stoop, squat, and bend during an 8-hour workday, whether or not you need to elevate your legs because of problems with swelling, whether you have to go to the bathroom and how often you have to go to the bathroom and how long you're going to be in the bathroom, whether you have to take naps because of fatigue, whether or not you have problems with side effects of medication, and whether you have problems with concentrating and starting something and staying on task, whether you've got good days and bad days, and if so, how many, whether you've got problems with your memory, whether or not you have problems with stamina and the ability to complete a full day of work, whether you would miss time from work and how many days you'd miss during the course of a month, whether you've got problems with depression or anxiety that would interfere with your ability to function. Now, this is not a laundry list of all the questions that are asked on a residual functional capacity form, but I hope that you understand that having a clear understanding or an outline of what it is you can do from a physical standpoint, a cognitive standpoint, and an emotional standpoint will help the judge understand what it is you can do. Because as I said, if the Social Security Administration can't figure out, most likely your claim is going to be denied. Many claims are lost because the applicant doesn't get a residual functional capacity form, the right one, or their doctor just doesn't fill it out properly. Worse yet is the doctor who says, "I'm not filling out any forms. That's just not my job." These are some of the many reasons why you should have an experienced Social Security disability attorney at all stages of a Social Security disability claim. The initial application is confusing. It's designed to give the Social Security Administration a reason to deny your claim. More often than not, the applicant just doesn't adequately explain their work history in terms of what the functional and cognitive requirements were, and many applicants never submit a residual functional capacity form. Do you know that over 2/3 of claims are denied at the initial application stage? That means you've got to file a request for reconsideration. And unfortunately, many applicants make the same mistakes they made at the time of the initial application. And when your claim is denied, and most of the time, 2/3 of the time, in fact, the claims are denied at the request for reconsideration stage, you get to file an application for a Social Security hearing, because of course you don't want to give up. But when you have to go to a hearing, you're having a trial. Statistics show that those who have representation have a greater chance of getting their benefits than those who don't have an attorney. Make the call, Cavey Law, 727-894-3188. I look forward to explaining to you what needs to be done to get you the Social Security disability benefits you deserve.